here in a different capacity tonight. We are both members of the singing group called Caribbean Witness. I was a manager of that group. In fact, I also managed her. At the time, I was a personal manager and as well as manager for the group. And we have many stories to tell, but she's not here for that tonight. She's here in a different capacity. She has become an attorney at law. And you know these lawyers, once you say hello to them, you have to pay them money. Once you walk into their office, you have to pay them money. Once you say hi and you smile at them, they charge you, just for the smile. But tonight we're getting her free of charge. So we're going to take full advantage of that. I want to say in advance, thank you so much. And I want to introduce to you and hand the mic over to Marilyn Destiny Joseph. And by the way, she has won not just one competition, she has won many things, including international awards for singing as well. But as I said tonight, she's here as attorney Marilyn Destiny Joseph. So Marilyn, good evening, thank you, and welcome. Make sure she can unmute, please.
Hi, good night to everyone. It's such a privilege to be with you all tonight. And thanking God for the time that He would use me to minister in this capacity. As Professor just said, I'm Marilyn Joseph. I became an attorney around 12 years ago. And that and all is just God. It's only God who could have done that. So tonight, I just want to minister from the capacity as an attorney, but also as a minister of the gospel of Jesus Christ. All right? And tonight I was asked to speak on estate planning and the importance of that and what really is estate planning. All right? It's an advanced planning of and management of your and distribution for your assets upon your death. So you make your plans before you die. All right? And so that basically is what estate planning is about. All right? And typically it is done through a will, a trust, insurance policies, or even through a deed, leaving yourself a life interest. So we're going to go into all of those things. But why is it important to plan for your death, upon your death, why is it important? And this is important to God too. In Proverbs, I think it's 13 and verse 22 says, a good man leave an inheritance to his children's children, and the wealth of the sinner is laid up for the just. It does not mean that if you don't leave an inheritance, you are not a good man. All right? Because there are a lot of people who are leaving inheritance, but it doesn't mean that they are good. All right? But it says that the good man leaves an inheritance to his children's children. And that says to me that the good man's inheritance is able to last because the wealth of the sinner is laid up for the just. So it is transferred to the just. And therefore, the wealth of the righteous person, the good man, can be passed down to his children. And a lot of times we think about wealth as only money and property and so. There is spiritual wealth, spiritual blessings that come down through the generations. All right? And that is equally or even more important than possessions and monies and all of that, right? So it's important though to God, because if you look at even the genealogy and all of that. Who begot what and what this one did and what that one did and all of those things. Those things are important to God. And even in our lifetime, because you're saying, well, that is old time, that's in the Bible and things. But even now, what we do as we pass from generation, they say one generation shall sing his praise to another generation. And that is important to God. All right? That we keep that succession, whether it's in wealth, spiritual blessings, or whatever it is. All right? And what we do during our lifetime, it affects our generations to come. Whether we decide to live for God, to walk in righteousness, to walk in holiness, or whether we decide, look, I just living wine, woman, and song and so, whatever we do affects our generation. All right? And therefore, even in planning our estate, we're going to deal with assets, really. But what I want you to think about, the spiritual side of it is equally as important. All right? Let me just give you a testimony. Is it okay? Before I get into the teaching. Some years ago, talking about plenty years ago, probably about 20 years ago, the Lord told me I had bought a car. I paid $45,000 for that car. And it was a car that I really, really loved. And, it's to feel good to drive that car. And the Lord told me to give that car. And I went to my husband and I told him about it. He wasn't too, I think, because that's the family car, that's all we have, But the Lord told me to give that car. And I remember my son, my older son, he said, Mommy, like poverty talking, how you going to give away the car? We don't have a car, long time we want a car, we finally get a good car. Why are you giving away the car? I said, no, the Lord told me to give it. So I sold the car and I gave the money. I gave all the money. I didn't keep back anything for myself. I gave all the money. And I can tell you, as of today, the Lord has blessed me and my family with cars upon cars. My nieces, my nephews, my people who are around me, my sons, my husband, myself, we struggle to even buy a car and to do all of these things. But God has done it because of the giving. And so there's a spiritual blessing also that comes with our giving and all of those things. And all of that, I see it as estate planning. Because as you give unto the Lord, as you walk right before the Lord, even with that, you are preparing a place in succession to those who are coming behind. All right? So we want to deal with the assets tonight. All right? It's important to do some advanced planning so that there could be succession in the generations to come. And a lot of times, when we don't do it, a lot of times assets are lost or gets into the wrong hands. All right? And so therefore, you need to think in advance. And sometimes you say, well, I don't have nothing. You'll be surprised how much you have. You'll be surprised how much you have, even if you're saying I don't have nothing. It is important for you to deal with look at what you have and deal with what you have and think about the generations to come. All right? So today we want to deal with what is a will? Why make a will? What is required for a will? What happens if a person doesn't make a will? All right? And then we're going to go into, if we can reach so far, what is a grant of probate and what is a grant of letters of administration. All right? So let me just think. A will basically is a legal document that the testator, which is the person making the will, puts what he requires to be done with his assets, whatever he owns. What is to happen after he dies? Who is to inherit? Who is to benefit from whatever estate he has? Okay, that is what the will does. It appoints somebody to handle it, which is the executor or the executress, to handle the distribution of the stuff, whether it is property, monies in the bank, shares, whatever it is. It appoints somebody to deal with it, to actually apply for the grant and distribute. All right. So the will basically is a document, a legal document that you place into the hands of the executor so that that person can carry out your wishes upon your death. All right. Now, why make a will? You know, you're thinking about why make a will because, you know, a lot of people are afraid to make wills because they think if they make a will, it means that they're going to die. You would be surprised how many people think that way. Anybody ever thought of that? I don't want to make a will. I want it to be a little more interactive, so if you could wave
Oh,
or
yes.
yes.
Oh, yes. Thanks.
All right. All right. Because if it is, you know, you're saying, well, if I make a will, I might die, or you're contemplating death, if you know, you are making plans in advance. And we do that all the time, day to day. You know, you want to travel next year. So you make plans. You're not going to spend out all your money and do all kind of thing now. What you do, you make plans and you save your money and all of that. You put it aside because you want to go on a cruise or travel or whatever. You make plans. You have to go out tomorrow. You have to go to work tomorrow. You need clothes, whatever you need in the transport, whatever. You put everything in place. You make plans. And nothing is wrong with making plans for what happens to you after death. All right. So the will is what takes all the information that you would like to deal with your estate. Now, a will is a document that you can change every Monday morning. So today you may put Susan and Deborah and so to inherit your house and the money in the bank and whatever it is. And Susan get your vex tomorrow, tomorrow, and this one. You can change your will anytime. And that's the beauty about a will. It only comes into effect when you die. Okay? So you can make 100 wills. But the last will, that's why they say the last will and testament. So the last will is what is going to stand. All right? So the good thing is that you can change your will to suit, because sometimes, you know, very early you might want to leave it for your grandchildren, or you have grandchildren yet, and you leave it to your children and then leave things to your children and say, look, I want to include my grandchildren and all of that. You can change the will concerning that. Now, if you do a deed and transfer the property into your children's name and all of that before you die, you cannot change that. All right? The will is permanent. The deed is permanent. So you don't want to do that. And I have seen in the short time I have been an attorney where parents transfer property into their children's name before they die, and the children put them out. And they are out, they paid money, they built the property and everything, and they have no rights to it again because they transferred it into their name. So the beauty of the will is that you can change your mind, and it only comes into effect after you die. All right? So why make a will? As I think I mentioned some of the things before. You must make a will because you want to be able to decide even before you die who is going to inherit what, at what percentage, and all of those things. It is your property that you want to give or pass on. All right. So you can determine who gets what, the percentages and all of that. You can decide that even beforehand. All right. By your will. And we're going to go into how to make a will and all of that. What is required, you must have some assets. So whether it's a television, some gold, jewelry that your grandmother left, whatever it is you may have, you can put it into the will, all right, for who you want to inherit. Anybody can inherit from your will. So if you decide I'm not giving any of my family any of this, family haven't been good to me, they haven't, whatever it is on the thing, and I want to give it to charity or even the vagrant on the street, you can leave your property, it is yours to whomever you want, all right? So this is what the will does. Now, what is required for a will? You must, well, besides the asset that you're going to put into the will, and sometimes you may not have something at the moment, all right? So when there's a clause that you put into the will that captures things that are future. So when you're doing the will at the time, you may not have, let's say, land or so, but there's a clause that you can put in to the residual estate that can cover anything else that you would accumulate after making the will. All right. So what is required is the assets, the person to be the executor or executress of the estate, and 2 witnesses. All right. Remember the Bible says in the mouth of 2 or 3 witnesses, you must have at least 2 witnesses on the will. All right. And it must be dated. The testator, which is the person making the will, must sign in front of the 2 witnesses. That is a must. And also, the witnesses must sign in the presence of each other and the testator. If that is not done, the will can be challenged. Okay? So, when you're doing a will, all right, the will, first of all, it must be in writing. And a lot of people will leave property and tell Kenneth, well, that is your, oversaw is yours, and this one, oversaw is yours, and part of this, and that is how they leave the property, and it's a whole mess after. So it, it must be in writing. This will must be in writing. The word of mouthing don't work. I'm dealing with a lot of those cases where people come in and grandma did give me that, and she did say it in front of everybody, and all of them know that, but all of a sudden everybody got amnesia, nobody remembers anything. All right? So it's important that it is written. All right? And I said there must be 2 witnesses. There must be an executor or executress, and the persons who are benefiting under the will cannot be witnesses. All right? So if you're leaving your jewelry to some, and Sam cannot sign as a witness, all right, under the will. Everybody getting that so far, right? All right. So what happens?
Could you repeat it one more time, please? Someone is asking.
Okay.
Thank you.
Repeat what? What exactly?
What you were just explaining just now about
making the will?
Yes, the witnesses.
Okay. What is required for the will? Well, you have to know what assets you have. And even if you don't have the asset or have anything in mind, you can do, of course, or leave all my possessions to my daughter, Susan, leave all my possessions to thing and all my residual estate or whatever it is to her. All right? But you must have an executor of the estate, somebody to actually probate the will and all of that. It must be stated. If it is not stated, if it doesn't have an executor on it, then it will have to be, I will explain about letters of administration with the will attached. All right, that is the application that would have to be made. It would not be a grant of probate that has to be made. I'll deal with that coming along. I think I'm jumping in front of myself. But it must have an executor, or well, executor is a man, executress is a woman. All right. Whoever is saying, it could have 2, it could have 3, it could have up to 4. All right. Executors. So if you want your 2 sons to handle it and whatever, you can put that, or your 2 daughters or whatever. There must be, it must have also 2 witnesses. All right, so that they would sign, put their address, put their whatever title they have, or whatever, what current clerk 1 or whatever it is they are. They can put that farmer, whatever, taxi driver, whatever it is. They can put those things onto where they sign. So they sign it. So 2 witnesses. The 2 witnesses cannot be benefiting under the will. All right, the executor or the executress can be benefit. They can be a beneficiary under the will, but they cannot be a beneficiary if they're going to if they are witnesses. Okay, and so there are 2. You must have 2 witnesses. The executor, which is the person making the will, must sign in the presence of those 2 witnesses. Now, what is in the will, he does not have to divulge what is in the will, or she does not have to do that. The persons who witnessing is witnessing him signing, or she signing the will. All right, so the testator can decide, I'm going to say what is in the will, let them know what is in it, or may not want to do it. All right, so the person can block off part of it and say, this is my will, and sign, and let them sign below, and not so they don't have to know what is in the will. All right, but they have to sign, see the person sign, and also sign. They both have to sign in their presence and in the presence of each other. All right, that is very important. The will must also be dated. If it does not have a date, it will not, it will be void. Okay? All right? That is clear, or do I have to go back to anything else?
Could you explain exactly what the executor does? Is that the person who sees about what do they say about?
This is the person that administrates the estate in terms of apply for the grant, all right, pays out all the debts and all of that, and distributes the estate according to what is in the will. All right, so the executor or the executress would be responsible to apply for the grant of probate, and also pay out all the funeral debts and whatever debts the person may have. If it's a court matter and debt has to be paid off, owing the bank or owing whoever, that has to be taken care of first, and then distribute according to the will. All right? And so it's an awesome responsibility for the executor to take up that responsibility. It's awesome. And they have to do it according to the will, all right, which would be according to law. All right, understood? Or so?
Yeah, and so that person should be a professional then.
Not necessarily, because once a estate, when I say estate, whatever assets the person have is over 4,008, you need an attorney. Right? Mm-hmm. You have to get an attorney so that person will hire an attorney to actually make the application.
Oh, okay.
All right? Yeah. So, but that person will be responsible, and after the attorney gets the grant, that person is responsible to take that grant to the bank and withdraw the money, or transfer the property, and that person would be responsible for that. But even in that, when they're doing the deeds and so to transfer the property, they would still need an attorney to do all of those things. All right?
Okay. Before you
Understood?
continue, I didn't
Mhm.
ask if you wanted to take questions as you go or wait until the end. We have somebody's hand up for a question there.
Yes, go ahead.
Hello, Sherry?
Yes, sure.
Good evening, Sister Marilyn. I just wanted to find out if an executor or executress can also be named in the will
Yes,
as to inherit.
yes. They can be a beneficiary under the will, yes. But they
All right,
cannot
thank you.
be a witness. All right,
Okay,
if they're benefiting.
all
Now,
right,
if
thank
it
you.
is, yeah, if they benefiting under the will, they cannot be a witness. All right, or the executor cannot be a witness. All right, but the person could benefit under the will. Any other question so far? How are we going?
Okay, now make sure your question has to do with what she has spoken about before,
Yeah,
please.
because we're going further.
Yeah, we don't want to ask any question concerning anything that she hasn't talked about as yet. Janet?
Good afternoon, everyone. Sister Marilyn,
Hi, good afternoon.
how are you doing?
I'm good. I'm good.
Okay. How long after death must a will be probated? And then, if it is not probated within that time, what happens?
Okay.
Thank you.
Okay. Usually, if you're the executor of the will, usually you are given 1 year, 6 months to 1 year to actually make the application and all of those things, right? If it is that the person does not do that, and a lot of times people don't do it because they don't have any money. The estate may have a property, but there's no money to pay the lawyer to make the application. So unless the beneficiaries would come together and say, look, we want to pay this person, and we would contribute to pay the lawyer or whatever it is so that it could be done, a lot of times the estate remains there without being probated. All right. But usually it's within a year, within 1 year, they are supposed to do it. If they do not do it, all right, you can petition the court to have them removed as the executor of the estate, as one of the beneficiaries, that is. You have to be a beneficiary under the will to petition the court to have that person removed, and you can be the personal representative. So what will have to be made is application that would have to be made to the court would be letters of administration with the will attached. All right, so that's the route it is. So it will go according to the will, but it would be letters of administration. All right, understood? Understood?
Okay, yeah, we can move on.
Yes.
Yes.
Thank you.
Okay. All right. So what happens if somebody does not make a will? All right. And I have seen it over and over again. Daddy died. He left 2 cars and a truck. All right. One son come and take the truck. This one, they take that. This one take that. And then somebody move into the house and put out the others. And big bacchanal, big bacchanal, big bacchanal. You don't want to leave your family in turmoil and wondering what to do and all of those things. All right. So it is better to make a will. But if somebody should die without leaving a will, the law steps in to say who can make an application to handle the application for letters of administration, and also who can benefit. Now, letters of administration is not a letter. Is a document you get from the High Court after an application is made. So a lot of people came, the bank tell me to get a letter of administration. I come to get it, thinking that we could just write a letter. No, it is a document you get from the High Court. It is called letters of administration. The document you get from the High Court after an application is made. So when somebody dies without leaving a will, it is called intestacy, meaning that they die without saying how their estate is supposed to be distributed. All right? So the law steps in to say who can make the application and who can benefit. All right. So instead of you now deciding who to get your estate, the law steps in now to say who can make the application and who can benefit. So it may very well be persons that you did not want to benefit may very well benefit because you did not make any allowance or did not make a will. All right. Somebody raising their hands?
Auntie Gail?
Yeah, hello. Hello, good night, Sister Marilyn.
Good night.
I have a granddaughter, right? She's a minor, but I'm saving for her, all right? But if like today or tomorrow something happens to me that I don't,
Okay, I'm coming
what?
I'm coming to that just now. All right?
Okay, all right.
I'm coming to that. All right. So
Sure.
if you don't leave a will, all right. And if I forget, remind me, please, because I have it in mind to come to that, right? If I skip it over, let me know, right? Right. If you don't make a, so the law now steps in to say who can make the application. The first person who can make the application is the spouse, so it's the husband or the wife. All right. The second person who can, if there's no wife or husband or so, right, spouse, then any one of the children can make it. If there are no children, no husband, no wife, no children, all right, then the parents of the person, it goes in that succession. It goes to the parents of that person. If the parents are dead, then it goes to the sibling. Any one of the siblings of the person can make the application. If there are no siblings, then it goes to nieces and nephew, and it goes down the line like that, okay? Any one of them, that's just to make the application. Now, if it is to make the application, let's say, okay, the man had a wife, the wife can make the application. How is the property now, or whatever the person has, is to be divided? It is supposed to be divided half to the wife and half to the children. So if you have 20 children, half of the estate will go equally to the children, half to the wife or the husband. All right? That is how it works. So the child that you didn't want to give anything, on the law, will inherit her or his share unless you make a will. All right? That is all. And if you don't make a will, the person that you may not even want to handle anything may very well be the one who is handling all your assets. All right? So it's important. I want to stress that how it's important to make the will. All right? So the grant of probate, when you make a will that is valid, there's an executor, there's beneficiaries, there's 2 witnesses and all of that you need. All right, there's a date and all of those things. Once it's a valid will, all right, the executor or the executrix can make the application for a grant of probate. Now, this is an easier route. If there's a grant of probate, if there's a will, it takes a shorter time for you to get the grant. If there's no will, then it takes sometimes years. Y'all hearing me? It takes, I am dealing with some now. I applied for it in 2017. I am now getting the grant. One of the reasons there's a backlog at probate registry that they've been dealing with for years, and it's just like that. The thing about it too is that they have to make sure that you are the one entitled to the estate. I am dealing with a case now where one son applied for letters of administration for the father's estate and putting out the others now. And he lied on the application and said that he is the only child of the father and only person entitled to the estate. So now we have to make an application to the court now to have that letters of administration, that grant set aside, and for them to deal with the estate now, to include the other siblings and so. All right. So the court now has to be sure that you are the person, you are the right person. They have to do their investigation. They have to put it on the papers. They have to give it time so that people could come in to say no, and query it and all of those things. They have to give time. So that is why it takes such a long time when you're doing letters of administration. All right, because they don't want to give the asset to the wrong persons. All right, or leave out anybody. So they have to take their time and do a lot of investigations before they issue the letters of administration. Whereas the grant of probate, everything is in the will, the executor is named and all of that. It is an easier process. All right. So typically,
Can I ask you quickly, do you have to register a will like you do a deed? Because I'm thinking
No.
anybody can write a will. So anybody can write a will and on a piece of paper and that kind of thing?
Once you have two witnesses, once it is written, it could be in handwriting, it could be typed. You have your two witnesses, the witnesses see you sign, they sign in your presence and all of those things. And you put down the executor, whoever it is, even if it doesn't have an executor of your estate, what is written in the will would stand, but it would not be a grant of probate. All right. So it will still have to go through a process in order for the beneficiaries to benefit. All right. Now you can write up your will, and you could even Google and get how to do a will and get all the different parts of the will, and you can do up a will. But if you have a lot of properties and different things that you want to think, and if you want to do it like you want to give to charity and do all of those things, it is suggested, it is suggested that you get an attorney to do it. All right. But you don't need an attorney to do a will once you know what you have to do. All right. So you can, now, a lot of people do wills and they put it in their safety deposit box in the bank. And they alone have the key to go there, or the loan have the authorization to go into the box. What will happen upon your death, even though it's safe in your safety deposit box, nobody could destroy it or whatever, even though it is safe there, in order for them to get into your box in the bank, they have to apply to the court for letters of administration in order to get to the box in the bank, which does not make sense at all. All right? Because the bank would not allow you to get into the safety deposit box without having that grant of letters of administration. All right? So don't put your will in the bank in a safety deposit box, which you alone have rights to. If there's somebody else that could access it, maybe then. All right? A lot of times people leave their wills with a lawyer. The lawyer come and die. Nobody know what the will is. Nobody. And a lot of times they don't even tell people that they made a will with a lawyer. And they pass, nobody knows what is happening and all of that. It is good to let people know what is happening, especially if you trust people, because sometimes, I have seen people where they want to kill mommy because mommy taking long to dead, because they want to inherit. It happens. All right. And if you don't want them to know what is in the will and all of that, that you can keep it private. But when you put it into a lawyer's hands alone, what happens is that sometimes the lawyer can't find it at the time or some kind of thing, or the people who are to benefit don't even know which lawyer and all kind of things. So the best thing to do when you do a will, you can lodge it at the probate registry in the Hall of Justice. That is free. All right? So you do your will, you get it signed by your witnesses and all of that, and you can lodge it at the probate registry in the Hall of Justice, free of charge. So anybody coming to make an application for letters of administration, they would have to bounce up, no, there's a will here. All right? Anybody coming, they saying, well, I am the wife, I am whoever it is, they will look at the will to see who is the executor or executors of the estate. And that person alone will be able to deal with the estate. All right? If the will is lodged there, it's better. All right? I did not lodge my will there because every Monday morning I told you could change your will. All right? But my children know where my will is. They know what is in the will. You know what I mean? And then so they have access to it. All right. So you can do that, or if there's somebody that you trust that you can give to the will to, that would keep it safe, and you tell, well, if something happened to me, Auntie Jean have the will, whatever, if you feel that is safe. But the best thing is to lodge it at the probate registry. All right? Understood? All right. So we're coming now. You may not want to do a will. All right? You may want to set up, now, if you set up a revocable trust, all right? Now, a trust, what you do with a trust, you transfer all your property into this trust. So it no longer belongs to you. It's no longer in your name. It is in the name of the trust. So you set up a trust. All right? Now, with this trust, there's no reason to go through probate and all of that. Your children or the beneficiaries under the trust can access whatever it is without paying any extra money, any doing anything, and transferring also because it's under a trust. It is not in your name. All right? Now, the best one is a revocable trust because you want to be able to change or cancel it or whatever it is during your lifetime. Excuse me. You want to be able to do that. Now, if you just set up a trust, once you transfer everything into the trust, you cannot revoke it. All right? So if it's the revocable trust, you can change, you can put in people, change it however you want. But if you just set up a trust like that, you cannot change it. And the property properties or whatever it have no longer belongs to you. It belongs to the trust. All right? So you can set up a trust for whatever assets you have, and therefore they don't have, your children or whoever don't have to do anything. Everything is under the trust, so no letters of administration, no that, they are just the beneficiaries. Now, what the person, I can't remember who it is, was asking about the granddaughter. What you can do under your will, you can establish a guardian under your will. All right, if the person is under 18, all right, you can set up set a guardian for the person. So whatever the assets that you plan to give your granddaughter or so, all right, you can leave it your son as guardian, and upon the age of 18 or 21, the money from the insurance will be transferred to her or given to her at different points in her life. Or if it's a property, you can say upon her turning 21, that the guardian would make sure that a deed is done to transfer the property into her name and all of that. So what the guardian will do will hold whatever asset until the child reaches 18 or whatever age that you put in the will for the person to inherit. All right, so that is how you would have to set up the will, giving guardianship to somebody, somebody to hold the property until the child reaches the age that you want them to inherit. All right, so that is how you would have to do it for your grandchildren if once they're under the age of 18. All right. Also, okay, what I forgot to tell you about the witnesses, they must be over 18. All right, the witnesses must be over 18. I forgot to tell you that. All right. So in setting up the trust, you need an attorney, because remember with the trust, all the assets are transferred from you into the name of the trust. All right, so you need an attorney to set up all of that, and who will handle the trust, who is the person in charge and whatever. You need to deal with all of that. So you can sit with an attorney, especially if you have a lot of assets and a lot of things, and how you want it to go to your grandchildren and whoever is and whatever. You can set up the trust. And also in the will, you can put, as I said, who you want to appoint as a guardian to leave whatever to your grandchildren and so on. All right? Or somebody, any children that are under the age of 18.
When you're setting up the will, the
Setting up
beneficiaries,
Mhm.
when you're doing the will, the beneficiaries, right? When you
Mhm.
name it the beneficiaries, do you have to name them by their given names? For example, if somebody leaving something for me and they say, I want to leave something for Professor from 98.1, will that work, or it has to be my name?
It is better if it is your name. It doesn't disqualify you from receiving it, but you have to prove, you'll have to get affidavits done of alias and so that you are really this person. All right. So somebody like from 98 and somebody else who knows that you are professor would have to come on affidavit to say, two persons to say that yes, this is Noel Richards is really professor, and so that is mentioned under the will. All right.
Okay, all right.
Mhm.
Ella Sheldon, you have a question?
I'm not on mute. Yes. Good night, Sister Mary.
Good night.
I heard you said in setting up the revocable trust.
Mhm.
Now, I'm thinking, if it is you want to, because you're doing this because you want to create generational wealth,
Mm.
and in
Succession,
setting up,
actually.
right, in setting up the trust, is it a situation that the trust can pay out a
Yeah, you can
certain
wind up a
amount of
trust.
money, a
Yeah, you
certain
can.
amount of money to the beneficiaries, and not just give them all of the monies
That is what you
at
can
one
do.
time?
Yeah, you can. That's what I'm saying. Even like the guardianship or so, the trust can be set up where at certain times they will get. Because let me tell you, you see, money gotten easily is lost easily. I have seen it. I had some nephews who inherited from my sister died, and she left a house that was almost paid off for, and she left 3 vehicles and so. And she left a will and everything, and they decide they're not going by the will. They're going, you take this and you take that and whatever it is. They lost all the vehicles. They lost the house that was almost paid for and everything, because it was gotten so easily that they didn't appreciate it. All right? And so we have to, what is good to do? I kind of going off course here. What is good to do is to give your children a bit of assets or whatever it is, or give them a bit of money and see what they do with it before. All right. And then you can determine, well, no, this person is not ready, because they're going to waste what you hard earned money and your hard earned assets. They're going to just, see how they're going to how they're dealing with their own lives, how they, whether they just spending while whatever they're doing, if they're on drugs or so, you have to know who you're passing this on to, all right? And whether they can handle it. So even before, if you see that they have a problem with money and all of that, maybe you can start off by training how to handle wealth. I know a friend of mine, she has 4 apartments, she has whatever, and the son just allows, just there, and every he's working, and she still has to give him money for gas and this and that, and he's not taking any responsibility. What is going to happen upon her death? And she gives, you know what's going to happen? People going to move in, people going to do all kind of things because he's not taking responsibility. So you have to know who you're passing on your assets, and so too. That's a big problem. All right. So wealth easily gotten is soon lost. All right. So, but let me get back to the question he was asking me. I think I went off course a bit. What were you asking?
No, I was asking if you can set up the trust in such a way, but I mean to say you answered it, to set up the trust in such a way that the money could be paid out incrementally, right?
Yes.
And
And
and you said
and the persons can wind up the trust at any time. They can say, well, we had enough of this trust, so let's sell out and distribute the money to all the beneficiary. It can be wind up like that. All right. But you can put it into place where they can say, okay, everyone who reaches 21 will get 10,000. And then they reach 25, they get so and so. So the trust will last until whenever the last person is paid out.
so
Go ahead.
I don't want to put you on the spot, but is it more advisable to set up a trust than a will? If it is as you said, money gained easily can and Solomon spoke about that, right? Right. And so from what I'm hearing, it is more advisable to set up a trust, because I mean, say, yes, I have a will, but I've been researching the feasibilities of going the way of a trust, right? And I'm just trying to figure out, what are the benefits of doing the trust as opposed to having a will.
Now, doing the will, you must get it probated.
Yes,
all
yes.
right?
Okay, go ahead.
Right. And also, when things are supposed to be transferred, property and things have to be, deeds has to be done to transfer it into the beneficiary's name. All of that is costly. All right? To transfer things and all of those things. With the trust, everything is transferred from the trustee, from the person into the trust. So there's no need for probate and all of that. Everything is already there in the trust. The thing about the trust is that when you set up the trust, somebody has to manage the trust. So monies would have to be paid for people to manage, or a person to manage the trust even while you are alive. All right, remember the will takes effect only upon death. But with the trust, if you set it up before, somebody has to manage. There are certain things that has to be paid yearly and all of those things. All right, that's the difference between the trust and the will. The will takes effect upon your death, but the trust now, when you set it up, somebody has to manage it and all of those things before, even while you're alive. All right? Understood?
Yes, clear.
All right, any other question? That's a real good boy. People,
I guess you can
people that
continue.
can they understand it completely. All
Yeah.
right. So it is good for you to specify in your will. Go ahead.
Before you move, we have just one other person's hand is up.
Okay.
Good evening again, Sister Marilyn. So my father is senile, and he wasn't married to the person he was with for all the years, but she passed away. Her granddaughter is presenting a document with her name, the granddaughter's name, on the document for his property, indicating that he has given the property to her, but his name is still there. There's no witness to say
what
that
kind
was
of
done.
document?
Well, I wasn't there. I understand there was a little altercation with some family members, and I understand it reached to the police station, and she presented a document.
No.
I'm not sure if it's a deed.
Okay,
but
land
her
can
name is-
only be passed by deed. All right.
Mhm.
Cannot be passed by some written something, or land can only be passed by deed. All right. Or if it is the will, even if you do the will and you leave for the person to inherit, a deed has to be done in that person's name. So land can only be passed by deed. So if it is she have like a statutory declaration, I'm giving so and so this my land at so and so, that does not count.
Okay, so that can be challenged.
Yeah, but if it's a deed, all right, if your father was senile at the time that
He was,
deed, right?
and I don't
Then
think
you
it's a
can-
deed. I
Okay.
doubt. Yeah.
Then you can get that deed set aside. All right,
Okay.
but if it's a statutory declaration, I'm leaving so and so and so, that does not count. Remember, the will has to have two witnesses. If it's a will he did, all right, it has to have two witnesses, and maybe if it is that at the time he is making the will, he wasn't in, he didn't have the capacity to make the will in his right mind or so, you can challenge that.
Yeah. Okay. I don't think he was in his right mind at that time. And more so, I don't think, because I understood that the police officer, the sergeant, was saying that he has seen this before, where they make somebody, because he could still write, and certain things they'll remember. So he would have signed something, but there's nothing to indicate, because if he is giving it to you, then it should be solely in your name, right? And
What you mean? What you mean? If he's giving it to you,
based on what she's saying, he gave her the property, but whatever she presented had her name on it and his name, like they are co-owners.
No, but you can do that.
Okay.
In terms of, that's another thing that you can do when you have children or so, and if you want, you can transfer the property before you die. But you're giving yourself a life interest in the property so that the children can't put you out. So
Okay.
you are allowed to live in the house until you die, and they can only inherit after you die. So if it's a deed that was done, giving him a life interest in the house, and then for her to inherit it, well, that's a different. No,
I don't think it's that, because
That
it
may be
happened
done.
after his wife died. Well, and before that, when he was still in his right mind, he told me he put her name on the property, which is the common law person, and after that, all his documents went missing. And well,
So how did he put her? Well, that and all you have to investigate. How did he put her name on it? If it is that he did a deed giving this lady the half of his property or so, if she died before him, you have to see how they held the property, whether it's in joint, we're going into all kind of thing, whether it's in joint tenancy or tenancy in common. If there's joint tenancy, the last person standing gets the whole property. If it's tenancy in common, half or whatever share, if it's 10 people or how much, whatever share goes equally to all the persons on the deed. So if it is that he did a deed transferring the property to his common law wife or whoever, you have to see how they held the property, whether it's in joint tenancy. If it's in joint tenancy, it all goes back to him because she died before him, right?
Yeah.
So there's no share to her children or anybody. Everything will go back to him, all right?
Okay. All right.
I wanted also, I don't know if there's anybody in a common law relationship online, right? And a lot of people saying, well, I live with the man 5 years, I make children for him and so, and he come and died now, and I have rights, okay? Now, if you're in a common law relationship, the law has changed. Before there wasn't anything like that. The law has changed a bit to allow that, because a lot of times the children in common law relationships are being neglected and they lose out on inheriting what belonged to their father, from their father, all right? So, oh gosh, my time gone, but let me just touch on it. So, what if you're in a common law relationship and the person dies, what will have to happen is that you would have to apply to the court to be deemed his common law wife, and then you can make the court can say what is the amount that you are supposed to get. A lot of times, the common law wife can step into the shoes of the wife and get half share and half to the children, of all the children and so. But that common law wife cannot make the application for letters of administration. All right? So one of the children will have to do it. If there are no children, or if the children are under 18, that common law wife can make the application on behalf of the children. All right, but in her capacity as common law wife, she cannot make an application for letters of administration. All right, so there's a longer process now of being deemed the common law wife and then being able to approach the court to say what share you are supposed to inherit and who can make the application. All right. I have seen where there have been a wife of 30 years, they separated 30 years. And the man or the woman went and started this other relationship, but never divorced. That wife, ladies and gentlemen, is still entitled and the only one entitled to make the application, the first person, I should say, entitled, even though they have been separated 30, 40, 100 years. As long as she is wife or he is husband, that person is entitled to make, first person to make the application for letters of administration, all right, for that person's estate.
Wow.
Yeah.
What a thing.
Because that person never divorced, all right? And the loss is, and even for a survivor's benefit. I know a person who, she and her husband were separate for 30 years. And upon his death, she got the survivor's benefit. She got the money he had in the bank, even though he was living with somebody. All right? So, be careful about this common law thing, especially if the person is married. All right? But it doesn't guarantee that you are able to get property and so on. A lot of people put out money and they say they expend property and they work together. It's 20 years, me and this person together and all of that. And then let's say the person gets sick. And 6 months before they die, the parents and them come and take the person. You have to be living with the person at the time of death in order to be able to claim common law. So the family step in and take the person sick, take them 6 months and take care of them and the common law wife, who was common law, cannot inherit because you have to be living with the person at the time of death. Right? So it's very shaky in terms of that. All right? Somebody has a question?
Yeah, Julian Maynard, I saw your hand up. Could you ask a question now?
All right, I feel
Yeah. I wanted to find out when you make a deed and you can put it in the
your will or
your
deed.
will.
Mm-hmm.
And if a will is made after the will that you put for safekeeping, then the last will would stand, or the will that
Yes,
took
the
place
last
later?
will would supersede the other one. Yeah.
Okay.
So all
And
you have
what
to do
is
is to present that new will because it will have a new date and so. That's
okay? And
important
what
of
is
the
a
date.
living will? What is a living will? What is a living will?
Well, the living will, a lot of times people do call it a living will because me and my husband decide we're going to leave it for, leave all the property to XYZ. All right? But within the will, we made a promise to each other that, so if I die before, that whatever is stated in this will would continue. You cannot change that. You understand? So if it is, we have children or so, and we come together and we say we're going to make this will and promise to each other. So it's a binding kind of contract between the two people that, okay, upon my death, everything goes to you, and after to you, it goes to our children or so. You cannot change that. That's the difference. Remember, the will comes into effect upon death. All right. So if it is that it come like a contract that you're making with each other that that we would not change what is in the bill. All right.
Okay. But upon your death, it still have to be probated and everything as normal.
Yes.
Okay. All right. Thank you very much.
Okay. All right. Well, thank you all so much. I know I went over almost over the time, but thank you all so much, and I hope that you all heard something tonight that benefited and so. All right. Thank you all so much.
From what I'm seeing, we haven't heard enough because people are asking for a part 2. So we will have to discuss that if you're available for part 2, because I know there are some questions that were asked while you were singing, while you were speaking, and there were some questions put in the chat. And I know we didn't really deal with those questions. So I would like to ask you publicly if you are willing to come back again.
Yes, not a problem. Not a problem.
Wonderful. Okay, so I will chat with you, and we could. Well, in fact, when I say come back again, we have the rest of this week. We have tomorrow and we have Thursday. So if you're available any of these nights, tomorrow night or Thursday night, would be great. But I will chat with you. I want to put you on this. Let me not put you on the spot.
Yes.
Let me chat with you, and we will decide. But thank you so much for the information. Thank you for sharing with us. Listeners, I started off saying this kind of information you had to pay for, and and we're getting it free. So we want to say thank you so much. I don't know why didn't I go and be a lawyer, boy? Oh my goodness. You guys,
one of these days I'll tell you the story about that.
Okay. The other thing is, I hope you put Noel Richards in the will and not Professor. Just remember that. Okay. But seriously though, Marilyn, thank you so much for all the information you gave to us. I'm sure everybody learned not just something, but some new things tonight. And we all benefited from it. So thank you, and thank you. God bless you. We'll talk again about the next time.
All right.
Yeah, blessings to you.
Okay. Good night, everyone. God bless you all.
Okay, wonderful. Folks, this is the end of our ministry for tonight. Thank you so much for everybody. Joshua, do you have any announcement to make? Joshua?
No doctor churches, no announcement.
No, okay, no information. Okay, so folks, we are back here tomorrow night, of course, at 8 o'clock. The Zoom opens at 7 as usual. And we have some announcements to make and all of that, but we will let you know. But thank you so much for coming tonight. And I know what I would want to ask you to do. If you had a question that you didn't get answered, send it in the chat. All right, put it in the chat or send it in the ministry phone. Send it in the ministry phone, and we will see if we can get Marilyn to answer the question for you. All right. I think that's it. God bless you. Have a wonderful night. Remember, Jesus Christ says, a new commandment I give unto you, that you love one another as I have loved you, so you also ought to love one another. By this shall all men know you are my disciples, if you have love one for another. Also want to remind you, our EOY. Anybody know what is an EOY? SOE is a state of emergency. Or you all know what is an EOY? If I use the other word, you'll know. All right, you know what's the EOY event? End of year event, right? That is Saturday. That is Saturday. I hope everything is in place. I trust that everything is there. Is everything in place? Are we okay? Anything you need to let the people know?